It is my pleasure to introduce our next speaker, who is Tianna Raby. Tianna is a litigation partner at Forman Perry. She is a magna cum laude graduate of Howard University with a JD from Vanderbilt, which is in the best city in the country, Nashville. She has previously spoken on free speech and sanctions in the courtroom, as well as paying fact witnesses in civil litigation. Tianna is an active provider of pro bono legal services. She's rated AV preeminent by Martindale-Hubbell. She has numerous awards and recognitions. She's active with the Women and Children Advocacy Committee in Jackson, Mississippi, and she is on the Executive Committee of Goodwill Industries of Mississippi. She is on the steering committee of the Women's Fund of Jackson, of the Community Foundation for Greater Jackson, and the Junior League of Jackson. So here to talk to us about sexting, textual harassment in the workplace, even more dangers of smartphones and other technologies, is Tianna Raby.
Good morning. Everyone is familiar with the common phrase, he said, she said. And in the context of litigation, that generally means that we have the accused and the accuser offering different and conflicting stories on what happened. And so you may have to rely on sources to get to the bottom of it, and those usually include very difficult and muddy waters to get through. However, in recent times, with the advancement of technology and smartphones, texting has yielded a lot easier road for plaintiffs to bolster their claims against employers in the instance of sexual harassment and other state law claims. We began to see this decades ago with email, but now with the ease and prevalence of text messaging, the record in using those texts in sexual harassment cases and other cases has grown substantially. And so textual harassment is exactly what it sounds like. It's texting, harassing through text messages, and today we'll be talking about sexting, which is sending sexually explicit messages or photographs through smartphone text messaging or either other messenger applications.
Well, look, let's be fair. Credit where it's due. Wiener is just trying to keep the city from danger. Carlos danger.
Okay, so in July 2013, former New York U.S. Representative Carlos Danger, or either Anthony Weiner, returned to politics in the New York mayoral election. However, he became the subject of a second sexting scandal when it was revealed that he, as Carlos Danger, had text messaged a female and was quite embarrassed for it. Now, this actually follows the first sexting scandal in which he was found to have been tweeting inappropriate pictures of himself to a 20-year-old over Twitter. In 2010, Brett Favre was accused of sending X-rated photos of himself to a game day reporter while he was with the New York Jets in 2008. And although NFL's investigation did not conclude that Favre sent the text messages, he was fined $50,000 by the NFL for his failure to be forthright in the investigation. And then not long after, two masseuses with the team in the Jets also lodged claims against Brett Favre. And it's funny, my husband wanted me to change this to, I don't always text cheerleaders, but when I do, I always send a picture of my Dos Equis. So you all might have a reference for that. I will wear you out soon. You just need some attention from me. Send me something very naughty. Go to the bathroom and take it. When was the last time you got laid? Result was Tiger Woods. In 2009, Tiger Woods saw his marriage to Ellen Nordegren kind of go down in flames. And this is because of some of those text messages that I just read to you were revealed. And it was just one set of text messages that he sent allegedly to several women. The result was that he lost tens of millions of dollars in endorsements. He had a hit to his reputation, and some would say he lost his mojo. So you would ask, what does this have to do with you? Tiger Woods, Brett Favre, Anthony Weiner. It has to do with the fact that either one of them could be your employee in your workplace. And so we look now at the ever-evolving mobile workforce and the advanced technology with smartphones and text messaging. These numbers from the Pew Research Center and Forrester Research indicate that messaging is no longer a trend, but it's a full-scale form of communication. And so the challenge for employers and for attorneys who represent employers is to recognize that employees are texting, they have been texting, and they will continue to text on the job, on the clock. There's an increasing number of applications that promise to be the holy grail for textual harassers. So we have Snapchat, CoTap, and Confide. And one of the unique things about these applications is that they promise to disappear after the recipient has read it. And specifically for Confide, which is targeted for business professionals, its website provides off the record with self-destructing messages. Confide lets you say what you want, honest and unfiltered. Messages disappear after they're read, ensuring all of your communications remains private, confidential, and always off the record, until you get a screenshot of that phone or either get it off the server from the cell provider. So because of text messaging, we've seen lots of instances in the news where sexting in the workplace has caused great embarrassment and issues for employers. First, we have the FBI sexting scandal in 2013. And there was a rash of sexting cases that came out in a CNN report where the internal disciplinary reports from the FBI revealed that one employee was suspended for nude photos that she sent, and apparently it, quote, adversely affected the daily activities of several squads. Imagine that. In Santa Barbara, we have Under Sheriff Peterson, who had retired in October of 2012, and then later we find out that apparently he had been sexting a public information volunteer officer, and that during that course she was seeking additional positions with the sheriff's office. When their relationship soured, she was let go from that position and ultimately filed a claim against the sheriff's office. He liked to send her text messages and talk about things that were from the book Shades of Grey. She was able to provide those text messages, and ultimately for a volunteer position that she lost, she settled for $30,000. In another case in the news, we have Central Michigan University, in which two female soccer players accused their coach of sexual harassment, and they alleged that he manipulated them by laying the groundwork to having a sexual relationship with them, and he did so through text messaging. The coach initially denied the text messaging and the relationship until they turned them over. Ultimately, CMU settled the case before it became a lawsuit for $450,000. So what we're seeing is that we have the same laws but new facts. Federal, state, and local laws prohibiting discrimination and sexual harassment are not new. But the facts and plaintiffs being able to get farther than summary judgment and getting recovery, whether it's in settlement or jury verdicts, are new. And it's because now they have a record that they can provide that bolsters their claims against employers. And so for employers, the harassing supervisors or coworkers are handed this illegal behavior that now has a record, and it's no longer he said, she said. Generally, in order for an employer to be held liable for its employee's actions, that employee must have been acting within the course and scope of his employment. And so that may mean a variety of things, but usually that means that the employee was acting in furtherance of the business of the employer, or either that the employer ratified the actions of the employee. However, with regards to state law torts, even if the employer is not necessarily found to be vicariously liable, there may be some additional torts in state law that the employer can be found to be liable for, which include negligent hiring, negligent supervision. So even if the actual intentional torts aren't something that's on your plate as an employer, your failure to monitor and to know what's going on with respect to text messaging and your employee's actions could still be a problem for you. We'll talk about a couple of cases, and this one is the Fry's Electric case, in which yielded a seven-figure verdict and one of the largest per claimant verdicts for EEOC files. And this case involved two plaintiffs, one of whom was a sales associate who had been receiving lewd text messages from her supervisor. She then told another supervisor about it. When he reported it, he was ultimately dismissed. So she filed a claim for sexual harassment, he filed a claim for retaliation, and the EEOC filed the claim against Fry's Electronics jointly on their behalf. Ultimately, because of the text messaging in that case, the result was that there was a consent decree in which Fry's Electronic agreed to pay $2.3 million. We have another case, the Krutz versus Chiropractic Strategies Group case. In that case, Crystal Krutz was a receptionist, and she began in July. By October, her supervisor, Dr. Morgan, began to send her lewd and sexually suggestive messages. And he also tried to make other physical contact with her. After 2 years of receiving the text messages, she quit, claiming she was not comfortable working around Dr. Morgan. She'd forwarded these text messages to others in the clinic, but they said, we don't know what to do about this. And so she quit, saying that she wasn't comfortable, and filed a sexual harassment claim that she was constructively discharged. CSG argued that it was not liable for her, even though for Dr. Morgan's acts, even though she had been sexually harassed, because she had not taken the appropriate avenues in trying to report the claims and then see if there were any remedial actions that CSG would take. In the employment law context, the Farragher-Ellis defense is one in which allows employers to say, even though this took place or may have taken place, we do have procedures in place to address it and quickly remediate the problems. Initially, the district court sided with CSG, and however, on appeal, the 11th Circuit reversed this holding and said that Krutz had reported Dr. Morgan's behavior, that the text messages were very explicit, and a jury could reasonably find that CSG did not take adequate steps in addressing her concerns. Now, this is in the era of flip phones, and so I've taken the liberty of providing you with the text and what they actually say, but some of them were, how about you find out? I want to F-U-C-K you all over in here. I'll just say I'm from the South, and although we do curse, sometimes I won't do that now. You want to F-U-C-K on the desk after Nikisha leaves. Nikisha was one of the clinic supervisors. I want to F-U-C-K you. Do you want to? Let's make it saucy. It was this record that the court looked at in the 11th Circuit to determine that this was sexual harassment, that CSG did not take the appropriate remedial actions when she reported it. And this was a case that, but for those text messages, the employer probably would have been successful at summary judgment. And these are some more. Come in and suck it and I will feel better. Another case in which we have another flip phone and screenshots. And although back in the day we had flip phones where you had to take the screenshots, and we've had all of this evolution of technology with our smartphones, screenshots still have been the issue with even the disappearing text, as I mentioned earlier, because even if the text itself disappears off your phone, if the recipient takes a screenshot, their record still is there. And so in this case, in Cherry versus Shaw Coastal, some of the text messages that became an issue were, you're missing the dipper. You are too sexy, you drive me insane. I love you so much, my heart is in pain, you're sexy. Your voice always puts me to slumber. Oh, blank, I got the wrong number. In this case, the Fifth Circuit was looking at a same-sex claim of sexual harassment. And in this case, the district court ultimately held that although there may have been some sexual harassment, because the harasser was not a homosexual, there was no liability for the employer. However, the Fifth Circuit overturned that ruling and held that the record in this case, the text messages that I just read to you, substantiated the sexual harassment claims, and therefore the employer was liable. Third-party claims. Actually, this issue is something that led to me to have this presentation. And you see the cartoon that says, "Stay away from my husband, you homewrecker." Unfortunately, Mississippi is one of the states that still maintains a claim for alienation of affection. And traditionally, you would have a spouse who has an affair with a rich paramour, and he or she is, off into the sunset with this rich person. Well, in Mississippi, sometimes you're having an affair with someone who's broke, so what do? You sue the employer as well. And so I am representing a venue management company that employed two very intelligent management level employees who thought it was proper to sexually text message a third party security guard. So she has all of these text messages on her phone, and she admits that our management level employee is very intelligent, told her to delete them. She wanted to savor them. So she gets home, her husband takes her phone into the bathroom, he finds out about the text messages, and lo and behold, I'm in 18 months of litigation trying to prove that my venue management company had nothing to do with the demise of a 10-year marriage in which the husband and the wife only spent 1 year together in the same home. So, ultimately, we were able to get summary judgment on that, but because of this alienation of affection claim that is very, very, very well settled in Mississippi law and the other states listed here, I had to do a lot of work, and my client had to spend a lot of money to make sure that under no circumstances they could be held liable for, first of all, alienation of affection, but also the accompanying claims of negligent hiring, supervision, and retention. So now we've talked about the potential liability based on these text messages. One of the ways that employers try to attack or at least defend these issues is to obtain the text messages. However, now there are all kinds of privacy issues that your employees may have against you in preventing you from doing so. And so whether you have a BYOD policy in which you ask your employees to bring their own device to work, or if you have company-issued phones, there may be some privacy issues that you need to address and have addressed in your policies. The City of Ontario versus Quan is one of the cases that gives us a little bit of guidance as private employers and as public employers, but a little bit as private employers about what we should do and what our abilities are as employers to search or monitor or audit text messages or other types of communications on the phones. In that case, we had a police officer for the City of Ontario who had a two-way pager, and he was given that pager to use for work, but he was also allowed to use it for personal use. It was a limited text messaging plan, and he was having a significant number of overages each month. And so what he did was started to pay for those overages. And in the review of whether the city should raise the text messaging plan and purchase a larger plan, they decided to look at the text messages and the messages that Mr. Quan had sent during work hours to determine if those were work-related messages that warranted a higher plan. In doing so, they found that actually they were mostly personal messages that had been sent to his wife and to another person who was there, and ultimately resulted in Mr. Quan being very embarrassed and filing a claim saying that his Fourth Amendment rights had been violated. Ultimately, the Supreme Court held that the business purpose for searching the phone was reasonable, and therefore Mr. Quan's rights had not been violated. So privacy concerns, what should we do as employers? You want to implement a privacy policy that's tailored to your business, and make sure you specifically list the types of messaging and communications that you're referencing. Don't make it general, make it specific, and then update it as technology changes. You also want to provide notice to your employees that they may be subject to searches or audits. With respect to this textual harassment and text messaging in the workplace as a whole, you want to make sure that you have a written policy and that you train on that policy, and that you also enforce and comply with that policy and don't allow ad hoc or unofficial policies to trump your written policy. Some of the best practices are to update the policies to address electronic communication specifically. If your employees are using BlackBerries, or if they're using Apple phones or smartphones, list those specifically. You also want to incorporate electronic communications into your respect in the workplace policies. And finally, you want to make sure that they know that it applies to both off-duty and on-work conduct. These are some of the things that you can do to make sure that you're able to respond to or defend these textual harassment claims in the workplace, and I encourage you to do so. Our key takeaways are that we are paying as employers and those that defend those employers for textual harassment through settlements, jury verdicts, or negative publicity. And so in the digital workplace, because it's no longer he said, she said, we really want to make sure that we're proactive in making sure we address those issues. Thank you.